together. It's complex, but I think important. So, in terms of the text of the letter, do members have thoughts in relation to that issue? Kelly?
I was going to say that, to be honest, I really appreciate this letter, and I think it's very good. The only thing is, I was sort of thinking, should we have an offer in that to meet, to discuss, but given the fact that it's another two devolved areas, it might be completely difficult to do that. But no, I very much appreciate this letter going forward, and I hope there's a response to it quickly. Yeah,
and I think that was kind of, in the initial stages, felt that a meeting wouldn't necessarily aid the speed of getting it done. And I have to say, I think the letter's well crafted. It touches most of the issues that are really germane to this issue. And again, thank the team for the rigour in that. Mm-hmm. So are members broadly content with the text that's drafted in the first instance? Can I ask that?
Mm-hmm.
Yeah.
Yep.
And then if there are minor changes that need tweaked, are members content that as chair I would work with the committee staff on those? Yeah. Mm-hmm. Okay. Clerk, are you content with that?
Yes, thank you very much.
Allows you to. Okay, members, moving on to agenda item 7 then. So we're now moving on to a proposed members' bill on UNCRPD, and we're receiving now oral briefing from Danny Donnelly, MLA. So, hey Danny, to Falcher Road.
Hi Danny.
Morning.
And hello Joanne and Tony as well. Good to see you again. So, members, the papers for this agenda item start at page 165. I would like to welcome the bill sponsor to the meeting and others who have come along with them and have no doubt worked with them on this bill. Danny, you're very welcome, and I invite you to make a brief opening statement on your members' bill before we move to questions from members. Thank you, Danny.
Thank you, Chair, members, thank you for the opportunity to present this briefing. In the interest of time and to ensure that I can give the bill the opportunity it deserves to be discussed, I will try to keep my spoken brief more succinct. Further detail is in the written brief that you have received, and I'd be happy to take any questions if something needs further explanation. Today's briefing is on private members' proposal to introduce a statutory duty on public authorities in Northern Ireland to have due regard to the United Nations Convention on the Rights of Persons with Disabilities, or UNCRPD. This proposal is intended to strengthen how we protect and promote the rights of people with disability in public policy and services. The briefing will cover the rationale behind the bill, including policy context and need, a summary of the consultation findings, legislative comparisons, and the next steps in our process. I would like to say before we begin that in the 2024-25 Assembly session, a search of all questions submitted by members to ministers containing the word disability identified 521 questions across 27 pages. These questions covered a wide range of policy areas, including transport, employment, housing, infrastructure, community access, health and social security. Importantly, they came from members across all political parties and directed at all departments, underlying that disability issues are not confined to any one policy area, political ideology or ministerial brief. The breadth of interest demonstrates both the scale of the challenges that people with disabilities face and the urgent need for coherent, rights-based framework that ensures disability considerations are embedded consistently across public policy and service delivery. This is precisely what the proposed legislation seeks to achieve. We know that 24% of people in Northern Ireland have a disability. That's more than 1 in 5. These are not small numbers or isolated groups. They represent a significant portion of our society who interact daily with public services across all departments. Ensuring that their rights are meaningfully considered in policy making is not a marginal issue. It is central to how we deliver fair, inclusive and effective public services. I think before we delve into the legislation and the need for this in Northern Ireland, it's important to understand what we are talking about. And what we are working towards. The UNCRPD refers to the United Nations Convention on the Rights of Persons with Disabilities. It is an international human rights treaty which exists to promote, protect and ensure the full and equal enjoyment of all human rights and fundamental freedoms by people with disabilities. The Convention applies established human rights principles from the UN Declaration on Human Rights to the situation of persons with disabilities. It covers civil and political rights to equal treatment and freedom from discrimination, and social and economic rights in areas like education, healthcare, employment and transport. I want to note several important points. The UNCRPD was adopted by the UN General Assembly in 2006. The UNCRPD has been ratified by 191 parties, that's 190 states and the European Union. The UK ratified the convention in 2009. This has been progressed in the UK through the Equality Act in 2010, but only applies to England, Scotland and Wales. Northern Ireland has yet to legislate on this issue, still being governed by the Disability Discrimination Act of 1995. And although there have been some amendments to this, the last was in 2008, we have not primarily legislated on equality in this Assembly, which personally I find concerning. In my written briefing, I discussed full details, and I'm sure members will be well aware of the workings of the legislative consent and devolution. So while the UK has ratified the treaty, the implementation of the UNCRPD into local legislation is the responsibility of the Northern Ireland Assembly, and there could be a discussion that Northern Ireland has not upheld its obligations under the Convention by doing so. As I've said before, with this bill, currently my aim is to introduce a statutory duty on the public authorities in Northern Ireland to have due regard to the UNCRPD. So what is due regard? The phrase due regard means that public authorities must give proper and conscientious consideration to the aims of the UNCRPD when making decisions. It is not enough to merely be aware of equality issues. Authorities must be actively thinking about and incorporate these considerations into their decision-making processes. With this bill, we are hoping to take a long overdue first step towards implementation of the UNCRPD in Northern Ireland. The scope of the PMB is limited, and this is extremely frustrating, as full implementation is ideally what we would want. However, our view is that any move towards equality is a step in the right direction, and we would hope by starting with due regard we could build on this. We are also considering possible avenues that could lead to full implementation on the back of this PMB, but this is pending legal advice, so we will not be discussing it today and will focus on the PMB as it is. To say that Northern Ireland's disability legislation is outdated would be an understatement. As I mentioned, Northern Ireland's disability discrimination law is still governed by the Disability Discrimination Act of 1995, the DDA, which means our primary disability legislation is older than this Assembly. And while there have been some amendments that still do not go far enough, Northern Ireland has never, as a devolved nation, set out primary legislation to bring our disability laws into the 21st century or reflect the rights-based approach set out in the UN Convention. Unlike Great Britain, where the DDA was replaced by the Equality Act in 2010, Northern Ireland continues to operate under the DDA with these amendments as Equal Opportunities Law is devolved. There have been no major legislative updates to the DDA in Northern Ireland since 2008, though the Equality Commission has called for these reforms to align with UK standards. I think it's important to note to the point that I am concerned it may be considered that the current legislation is enough, or that aim for parity of the rest of the UK will suffice. Parity with the rest of the UK should be a stepping stone, and we should strive for more. Northern Ireland cannot continue to be left behind time and time again. We need to be honest with ourselves and admit that we are not trying to change our current legislation. We are failing people with disabilities in our society. We have already been failing them for some time. The legislative imbalance between Northern Ireland and the rest of the UK has resulted in significant gaps in terms of equality law, especially for people with disabilities. A 2022 report from the Equality Commission and Disability Action highlighted several areas of policy and legislation in Northern Ireland which are non-compliant with the UNCRPD. These include the Mental Health and Capacity Act, inadequate protections against disability discrimination, continued use of involuntary ECT, use of restraint and seclusion in both health and educational settings, evidence of abuse and degrading treatment within institutional settings, inadequate play and leisure facilities for deaf and disabled children, lack of access to appropriate toileting facilities, underrepresentation of people with disabilities in decision making, and increasing levels of disability hate crime. The Disability Strategy Expert Advisory Panel recommended in December 2020 that the ways in which the UNCRPD can take legal effect in Northern Ireland should be explored. Professor Bryce Dixon has referred to the power of the Northern Ireland Assembly to protect human rights, and this is often overlooked. The Northern Ireland Act of 1998, Schedule 2, Paragraph 3C, provides the Assembly with the power to implement international obligations like the UNCRPD. Notably, Scotland's work on implementing the UN Convention on the Rights of the Child, the UNCRC, the devolved constitutional arrangement has meant that the Scottish Parliament has progressed on human rights protection beyond the European Charter of Human Rights in devolved areas. The Scottish Parliament has passed the UNCRC Incorporation Scotland Bill. This bill incorporates the UNCRC in devolved areas, meaning the protection and enforcement of children's rights in areas of devolved competence. The bill places an obligation on public authorities to comply with the treaty and encourages implementation through advanced monitoring and reporting mechanisms, and finally provides routes to remedy for violations of the treaty for non-compliance. This bill would require public authorities to have due regard to the articles of the UNCRPD and to produce reports on actions taken and gaps that impact upon their obligation to do so. In order to achieve this legislation would contain the following clauses. Public authorities would be required to pay due regard to the UNCRPD in their operations, and public authorities would be required to publish a report every 1 to 3 years on the actions they have taken to ensure they are paying due regard to the UNCRPD. We are also exploring a clause that would enable full implementation of the UNCRPD following this private member's bill, subject to legal advice. As outlined previously, the current focus is on progressing the due regard principle. My view is that introducing the due regard principle is a meaningful step forward, and I remain open to any provisions that would support full implementation. This reflects our commitment to embedding lived experience and co-design at the heart of our approach. Ultimately, full implementation remains the long-term goal, but due regard is a strong foundation on that path. I'm going to give just a few brief comments about my consultation findings. I have provided more detail in the written brief for reference, but in the interest of time, I will speak to a more general overview. Members are, of course, welcome to refer to the written brief for further detail. The consultation revealed strong and widespread support for introducing a legal duty on requiring public authorities to have due regard for the UNCRPD. Respondents saw the proposal as a vital step towards embedding disability rights into everyday decision making and service delivery, and with the potential to improve accountability, transparency, and the lived experiences of disabled people. While full implementation of the UNCRPD is the ultimate goal, many acknowledge that this proposal, if done correctly, represents a meaningful step in the right direction. While responses are mostly qualitative and not formally weighted, the overwhelming support for the proposal, ranging from 68% to 95% across various questions, indicates a clear majority in favour of this legislative change. Minority concerns, although fewer in number, provided valuable insight into the potential pitfalls and implementation risks that must be addressed. There was clear recognition that from the legislation to have real impact, it must be backed by strong enforcement, adequate resources, and a genuine involvement of people with disabilities throughout the process. Concerns around implementation, challenges, unintended consequences, and tokenistic involvement highlighted the importance of cultural change alongside legal reform. Suggestions to strengthen the proposal included extending the duty to private companies, establishing independent oversight, and adopting co-production models that centre on lived experience. Ultimately, respondents expressed hope that this legislation can move beyond both procedural compliance and serve as a transformative commitment to equality, dignity, and human rights for all. The consultation report is in its final stages, and we hope to have this published in the coming weeks prior to recess. Looking at comparable aspects of the legislation that cover the due regard principle, I will note several examples. I do want to make it abundantly clear that while these are positive steps forward, they still have a way to go, and my point is that the positive impacts can be made on a path to full implementation. The Rights of Children and Young Persons Wales Measure 2011, which requires the Welsh ministers to have due regard to the UNCRC, has been credited with transforming how children's rights are considered across government. It has led to the routine use of children's rights impact assessments, CRIAs, in policymaking. It influenced decisions on school closures and ensured that children's views were directly reflected in the COVID-19 response planning. Similarly, the Public Sector Equality Duty, the PSED, under the Equality Act of 2010 in England, which includes a due regard requirement, has driven measurable improvements in equality-focused policy development, particularly in areas such as the gender pay gap reporting and accessibility in public services. These examples demonstrate that when due regard duties are clearly defined, monitored and backed by political will, they can lead to systemic cultural change, improve transparency and embed rights-based thinking into how public bodies operate, outcomes that Northern Ireland has yet to fully realise. In terms of the Private Members Bill and their sanctions, I will set out 3 examples of the different types of sanctions for the idea of precedents from previous Private Members Bills, and this is simply for reference. The Private Members Bill brought forward by Jim Allister, the Civil Service Special Advisors Bill. The primary sanction is a statutory disqualification from holding a government advisory role, marking a rare example of a Private Members Bill imposing a career-ending restriction as a consequence of past criminal conduct. A limited review mechanism exists to permit exceptional appointments, but the legal default is a lifetime ban. Dahi Mackay's Single-Use Plastic Bags Bill. Sanctions include civil penalties for retailers who fail to comply with necessary requirements. Fines range from fixed penalties to higher variable penalties for serious or repeated breaches. Enforcement is administrative, with recourse to further legal action if necessary, reinforcing compliance through financial rather than criminal deterrence. Kelly Armstrong's Private Members Bill, the Integrated Education Bill of Northern Ireland. Unlike other Private Members Bills discussed, this Act does not contain criminal or financial sanctions. Instead, it relies on policy mechanisms and oversight to ensure departmental compliance, namely reporting duties to the Assembly and requirements for departmental strategy. How we wish to proceed in terms of sanctions will fall more in line with relying on policy mechanisms like Kelly's Bill, as our focus is also on systemic change through accountability rather than punitive enforcement. However, there are considerations to be made regarding fines or penalties for repeat offenders or those not working towards making meaningful and impactful change within the remit, paying due regard to the articles of the UNCRPD. Currently, we do not feel that judicial proceedings will be appropriate as a sanction. Our next steps following this briefing will include publishing the report on the public consultation. As I said, this is imminent and it will happen prior to recess. From this, we will have the development of the final proposal for consideration by the Speaker. If the Speaker accepts the final proposal and grants access to the Assembly's legislative drafting service, I will proceed to drafting of the bill in conjunction with the Bills Office and will seek formal legal advice on the provisions, including the possible enforcement mechanisms and sanctions. We will be continuing to have involvement with key stakeholders throughout this time. Once the bill is finalised, we will submit it for formal introduction in the Assembly. The bill will then proceed through the standard legislative stages. Throughout this process, we will work to secure broad political support. We will continue our involvement with DPOs and the wider disability sector to ensure that the bill remains grounded in lived experience and delivers tangible, rights-based outcomes. Our aim is to introduce the bill as early as possible in the Assembly timetable to maximise the chance of it passing during this mandate. In closing, I want to reiterate that this bill represents a crucial and long overdue step towards equality in Northern Ireland. It is not about adding complexity to public services or burdening departments. It is about embedding fairness, dignity and respect into how decisions are made and services are delivered. For too long, people with disabilities in Northern Ireland have been left behind by outdated legislation and patchy protections. This proposal is modest in scope but significant in impact. By introducing a duty of due regard to the UNCRPD, we are laying the foundations for a more inclusive, accountable and rights-based governance. This should not be a divisive or controversial proposal. It is an opportunity to unite around shared values and ensure that every person, regardless of ability, can expect the same standard of equality, respect and participation. I believe this bill can act as a catalyst for meaningful progress and I look forward to working with you all to make it a reality. Thank you, and I'm happy to take any questions.
Thank you, Danny, for that information and important work. And I actually am very, very struck by the fact that as we sit and we're trying to bring our legislation and the regulation into line and up to some kind of parity, we're looking at a situation where in Westminster they're today probably discussing items around removing supports for people with disabilities, and I'm very struck with the contrast of that. However, in relation to your own bill, so I'm aware of the 1998 Act, and you have, I think, extensively addressed the issue around due regard and why you have went with that form of words. The 1998 Act places a statutory obligation on public authorities to have due regard to the need to promote equality of opportunity and good relations, and equality schemes are approved by the Equality Commission. So how we know public authorities are really having due regard if all they do is publish reports? Do you consider that to be due regard, and have you considered if that's what due regard is amounting to, is there potentially need to strengthen the bill due to historic engagement or coming up to the mark on due regard? What's your thoughts on that?
Certainly, one of the themes in the consultation was about potential weaknesses of the due regard principle and the failure of that to deliver previously. And certainly we would see it as the potential for a driver of change, and having regular reporting, and there already is regular reporting to within the UK and the Northern Ireland mechanism. But we would see it here as the Assembly as having regular reporting would be a driver of change towards narrowing the gaps between the services delivered by Northern Ireland departments and the UN obligations, the UNCRPD obligations. So yes, there are concerns about the weaknesses involved in the due regard principle, but we think that on balance, having a regular reporting here in Northern Ireland of our public authorities should produce impetus and momentum for change towards UNCRPD implementation.
Okay, thank you. The disability strategy hopefully will become a reality soon. Are you aware, in terms of the work you have been doing, of the UNCRPD being included in the development of that strategy? And has the department given you any feedback in relation to the convention, in relation to their work on disability strategy?
No, I'm not aware. I'm aware that the advisors and certainly the disability community who have been pushing for implementation of the NCRPD are very strongly of the mind that it should be embedded in disability acts here, and certainly we would hope to see that when it is announced that there will be elements of that will act towards full implementation. I have written to the Minister for Communities previously about the proposal, and he has told me that he isn't able to bring forward full implementation during this mandate, but there's nothing in the private members' bill that I think is going to affect anything that his legislative timetable is bringing forward.
Okay, thank you. And the final one for me then, before I come to members, is, and you have set out the various steps of the bill, and thank you for that. However, we are very conscious of the potential legislative scrutiny workload that we may face in the remainder of the mandate. So can you give us any more detail in relation to the timelines for some of those key steps?
Excuse me, sorry. Sorry, Chair, just 2 seconds.
While you're going through that, the timeline, we are aware the timeline for introduction is going to be next June, so that'll probably kind of provide a deadline in that sense.
Well, certainly, now I would hope to have the consultation report is being finalised at the minute. That will be submitted to the Bill's office and to the Speaker's office before recess. And I would hope to introduce the bill early in the next session and in September. I think that gives us enough time, roughly 18 months, in order to progress through the various legislative stages.
Okay, well, thank you. I think it's one we will want, as this continues, we will want to keep a tight eye on that time frame. So if you can give that some thought in relation to the timetable. But thank you, Danny, for now. And I'm going to go on to members. So I have Kelly, Melissa, and Morris indicating at this stage. Kelly, go ahead, please. Nicola as well, please.
And thank you, Danny, and congratulations, having been there, done that. Take a breath, because it's a nerve-wracking thing to do. The Chair's already asked about this first step with the due regard. So the other thing that actually would be quite important to us as a committee, and we've spoke about it with regards to strategies, is about people with disabilities who have lived experience and their input. So how are you going to ensure that people with disabilities are embedded in the policy, not just designing it, but also the co-production of that, and then the monitoring going forward, and maybe even the oversight of that monitoring going forward?
Okay. There are various ways that this has been monitored already. We do have the UK group and we do have the Northern Ireland group. People report directly into the UN. I have some further points in this. Apologies.
You say the UK group, that's the and the Northern Ireland group that review the UNCRPD and how any of it's being applied here, or?
Bear with me, Chair.
Yep.
Right, yeah. So at the minute, it's the Disability Discrimination Act of 1999 that remains our core disability act. Apologies, Chair, I've lost my page here. I will come back.
Always, Danny.
Can I come back to your question?
Yeah,
Apologies.
No problem. No problem. Danny, take a breath, because I know exactly what it's like. Lived and breathed private member's bill for 6 years. It's a tough thing to do, but we look forward. This will be the committee it'll come to, so I'm sure we will see you plenty of times.
Yep. This is at a very early stage, Chair. I have prepared quite a lot of bits on this presentation, so apologies. Have you another question, or is anybody?
And if there are questions that you want to send us further information through, that's perfectly fine, Danny. It's not only yourselves in that position, I can tell you, sitting there, so don't worry about that. So, all right, Kelly. Yeah, Melissa.
Well, thank you, Road, Danny. Very welcome here. And again, you're to be commended for bringing this to the attention of the committee and developing this hopefully legislation down the line, which is definitely identifying a whole gap that's there. But 2 years, just that I wasn't that familiar with the terminology due regard, but whenever I heard of it first, I was looking at it, I was sitting thinking, that sounds weak, and that it could be something that would allow, we'll say, people or departments to just patronise the principle in itself. But then you also referred then to strong enforcement, and strong enforcement in the sense of anything it would imply as well that there are identifiable objectives here or identifiable targets. Have you thought about that, Danny, in a way that whereby people can be held to account whenever we use the terminology due regard, that we know exactly what it is that we want to hold them to account for? Would that be contained in that within the bill as well?
Sorry, apologies, Melissa. We would be asking for each department to report directly to the Assembly on a regular basis, and having a set of objectives that they would be reporting against, in the hope that the objectives will be narrowed. In terms of sanctions, we had looked at a couple of options, and the option about judicial impact ruled out at this stage, and certainly fines, I think, in comparison with other previous PMBs was something that we were looking at as well. But there are a range of possible sanctions that we are looking at the minute, and certainly that will be part of the further discussions with the disability community and the Bill's office. And I've also engaged with RAISE to produce a paper as well.
Thank you, Melissa. And go on then. No, I'll go to Morris and then I'll come back to our deputy chair. Morris, go ahead.
Thank you very much, Chair, and thanks, Danny, for the presentation. It's a very important bill that you're bringing forward, and I wish you all the best with it. But to ensure that it passes smoothly and quickly through the Assembly, have you had any dialogue so far with other MLAs and other parties to make sure that that passage is smooth and that it is supported? And I can't see any reason why it wouldn't be supported, because it is a very valuable bill that you're bringing. Congratulate you on that.
Yep, thank you, Morris. I have engaged with people, members from across different parties previously. We have had a debate on the UNCRPD in December previously, and various conversations during the consultation period from December through to February. particularly with other members who would have been involved in disability groups and actions previously. I'd be very happy for any member to get in touch, and I think I'd wrote out to all members during the consultation period if they wanted to be involved in the consultation to contact me directly, and I'd be very happy to have those conversations with anybody.
Just another one, Chair, to ensure that this here doesn't become a tick box exercise for local authorities, I do think, like others in the committee have alluded to, that there needs to be some pressure put onto what actually due regard means and what are the implications of not following that. So you've also said this is a first step. So how do you envisage this progressing as the mandate and future assemblies move forward?
It's my hope that in order to progress full implementation of the UNCRPD, that these reports will be a useful tool in highlighting the gaps that exist already and start to narrow those gaps, making the case for that here in the Assembly, and being able to progress that further with future mandates. Now, initially, it was my hope that this would be taken up during this mandate. Unfortunately, we obviously have a very truncated time, but if we can bring this forward, this will provide an evidence base for future policymakers in the next mandate to progress the full implementation of the UNCRPD.
Danny, thanks, Chair.
Thank you, Maurice.
Thank you, Maurice. And I'm now coming to our Deputy Chair, Nicola Brogan. Nicola, Lanneray, let it hold.
Thanks, Chair, and thank you, Danny, for your presentation. As everyone else said, it's a very worthy bill, so I do wish you the best with it as well. I have a couple of quick questions. You had said you had written to the Minister about the full implementation of the UNCRPD, and he wouldn't be able to bring that there forward just in this mandate. But have you had any engagement about your proposed private members bill, and what was the response from the Minister and the Department? Do they seem supportive?
Yep, we had written to the Minister initially, and then a second letter outlining the proposal. I haven't had any response from the Minister, but certainly his department is aware that it is being progressed.
Okay.
Well, proposed rather than progressed. That's,
okay, yeah. Proposed, fair enough. Have you done any costings on it, and are you confident that, you know, if the bill was to proceed and then be passed eventually, that, you know, any budgetary constraints wouldn't affect the bill?
Certainly costings is a very important question, and it is something that we are keen to address with the right research and careful consideration. Still very at the early stages of this bill, and the financial implications is an area that we're actively exploring at the minute. We do not have precise costings, but we have engaged with RIAs to prepare an initial report examining potential financial impacts. Fully recognise that the financial implications will play a key part in the bill's development and must be assessed in a comprehensive and transparent manner. Some areas currently under consideration include staff time and resources required for reporting and compliance, structural or physical adaptations where necessary, development or enhancement of IT systems, additional resourcing for oversight bodies such as the Equality Commission and the Northern Ireland Human Rights Commission, including potential increases in staffing and operational capacity, the possible establishment of a new independent commission or oversight mechanism. But at the same time, we think it's important to acknowledge the implementation of the bill may also generate long-term financial benefits. For example, increased worker participation, reducing dependency on benefits, improved mental health outcomes, lowering pressure on health and social care services, stronger social cohesion and inclusion, fostering a more connected and resilient society, and greater consumer spending and local economic activity as more people are enabled to participate fully in public life. We are committed to ensuring the financial case is fully developed and that both costs and potential savings are properly reflected in the bill's progress. I would like to add that the costs should be modest if authorities are already meeting best practice, and if they are not, that in itself would be a concern that would be highlighted and should be addressed.
Thank you, Danny.
Okay, thanks for that, Danny. I suppose just we've seen it before with bills being passed and then not able to be implemented fully because of the cost. So it's important. It's an important topic. But thank you for that there, and I do wish you all the best with it. Thanks, Chair.
Thank you.
Thank you, Nicola and Brian.
Okay, thank you, Chair. Welcome to committee, Danny. Thanks for the presentation and your paper. obviously, for this to progress, it needs to be selected by the Speaker. That's probably the major hurdle that you have. And we've less than 2 years now left of this mandate. So I don't know, do you get a standard reply, or have you had any engagement with the Speaker on this matter, or is it a standard reply that you get at this stage?
I haven't submitted this to the Speaker's office yet, so the consultation period's closed a couple of months ago. I'm currently compiling the report on the consultation, and that will be submitted to the Speaker's office before recess. So hoping for a response following that.
Okay, thank you. And in terms of other ways of taking this whole issue of support for people with disabilities and countering disability discrimination, have you fed into other processes? Have you had the opportunity to feed into the disability strategy, the draft strategy, which we're told is at an advanced stage, or to the TEO committee inquiry on gaps in equality legislation?
Certainly my office is looking at those. We haven't fed in directly. I know this is a Department of Communities, the disability strategy, but certainly I know other representatives would be. But certainly the TEO inquiry would be something we're looking into.
But it's at an advanced stage, obviously. I mean, and there will be some recommendations coming out of that. Also, I mean, in the RAISE paper, we've been given a copy of from April this year. In regards to UK law, it says the UK is a signatory to the UNCRPD. While the convention is not directly incorporated into UK law, it is given effect by separate legislation, primarily the Equality Act 2010. And then it goes on to note that the UN Committee on Rights of People with Disabilities have raised concerns the UK is not doing enough to consistently apply the UNCRPD. So, is it correct to say UNCRPD, well, it says here it's not directly incorporated into UK law, but a lot of those issues through the Equality Act give effect to the matters. But is it correct to say the UNCRPD then doesn't have that status elsewhere within the UK?
A very technical legislative question. I can certainly find out the exact answer for you. And, I'm aware the UK has signed and ratified, and the Equality Law of 2010 does not applies to England, Scotland and Wales. Certainly there has been ongoing monitoring on the UNCRPD, on the UK's adherence to it, and the last UN Convention on the Rights of Persons with Disabilities Committee report was published following an inquiry into the rights of disabled people in the UK in March just 2024, so just last year. The committee found that there was no significant progress on addressing the previous recommendations that were previously outlined in 2017. So there had been a long sustained period of no progress, and also highlighted that the UK government had failed to address any of the systematic violations of the human rights of persons with disabilities, and failed to tackle the root causes of inequality and discrimination of disabled people. So there is a significant gap between the UK meeting its obligations under the terms of the UNCRPD, and that's the most recent report in March 2024.
Yeah, I'm just querying whether it actually Northern Ireland would end up not aligned with the rest of the UK, but I'll research this more myself as well. But no, I certainly welcome all initiatives to help to advance the need to have more protection and legislation to support people with disabilities and help them in every aspect of their lives, including in employment.
Well, currently Northern Ireland is not aligned with the rest of the UK. We're way behind, and we would need to progress significantly in order to bring ourselves into line with the rest of the UK. But in doing this, this would ensure that people in Northern Ireland are protected, and there's no reason why we shouldn't go further than anybody else. Northern Ireland could be a leader here. We could implement the UNCRPD fully into Northern Ireland domestic law, as they've done with the UNCRC in Scotland. We could have those rights enshrined in our legislation here for disabled people here in Northern Ireland and be a leader in disability rights. So,
Yeah. Thank you. Andy, go ahead.
Thanks, Chair. And a lot of the questions have been covered. Danny, firstly, obviously, thanks for taking the initiative and bringing this forward. It's a very important matter, and Chair, perhaps I should declare an interest as a member of the disabled community myself that may be affected by any legislation introduced, positively affected, I perhaps might add. But just in terms of to recapitulate what you'd said, Danny, if the bill that you're proposing to bring forward is accepted and it were implemented tomorrow, what would be the difference that the disabled community would notice?
Initially, now it wouldn't be very much. Now, what in the long term we're hoping to build an evidence base to highlight the gaps in public services that are faced by people with disability, be that in education, housing, infrastructure, accessible public transport, for example. We have already reports that have highlighted huge gaps in these services, but we want to bring that together so that there's regular reporting to build that evidence base and push towards full implementation.
Yeah, and just on that piece around the full implementation, you'd said you'd obviously engaged with the DFC Minister and they felt that obviously it wouldn't be achievable within this mandate, which is obviously where we ultimately want to get to. Did they give any feedback as to the approach that you're taking and why they felt that they couldn't take that forward? And that's not to knock what you're doing, Danny, as we well know within this place. It's much ministers are supported much more to bring forward legislation than private members. That's not to say private members' bills aren't good and don't have a practical impact, but ministers are supported better. So did they give any feedback on that?
I don't have the correspondence with me. Okay. I think it was relatively brief, but I can certainly share that with you afterwards. And
if they offered you any additional support, and I appreciate obviously you'll share the information, but support to ensure that the bill that you're proposing is as strong and robust as it possibly can be?
Not as yet, but certainly I would be very appreciative for any such support.
Yeah, and certainly, obviously, it'd be for the committee to make a decision, but I'd be keen that the department would support you in that, and there's that co-production approach taken, and it's important that they do that. And just the final point, perhaps, Danny, and obviously you provide a lot of information in your briefing document, and happy to pick up after this with you as well. You'd mentioned in terms of financial implications and costs, and obviously that should never be an excuse for not taking forward measures, and a lot of the costs that you had talked about appeared to be directed toward government. Do you envisage any costs for wider society, and where that is the case, is there anything that you feel needs to be taken forward to support wider society to make the improvements required?
Certainly the scope of this bill would be specifically on public authorities. I don't envisage any costs outside that at the minute, although I'm happy to be corrected. I have asked for a raised paper to help educate me on any potential public costs that might incur. At the minute, I haven't seen any, but certainly it's something that we would be looking at if that was raised.
And just final one, maybe perhaps that's come to mind. Is there anywhere else that's taken a similar approach to what you're taking that you can point to?
Yes, there have been two countries, certainly the Scotland example that I'd given you. Other countries have brought it in as well, or brought various different approaches. Bear with me, I'll just see if I can get the...
In terms of the approach that you're taking rather than the full implementation, which...
yes, now, bear with me, I'll get the exact quote here, Andrew. This is me thinking I've been very organised, and then
you're grand. You can follow up with me, Danny. Obviously, there's a lot of information. You've obviously come well prepared in that regard, and sometimes flicking through to find it is challenging. Obviously, and we can engage. And I'd be very keen to obviously see the consultation document once you obviously have that pulled together. But from myself, best wishes, and I sincerely mean it. If I can help, you only have to ask.
Andy, thank you. I've just found the page here,
Yep.
and I'm happy just to highlight briefly the three examples. Scotland's UNCRC timetable was due regard as a first step. So the Children and Young People of Scotland Act 2014 had an earlier due regard approach for its UNCRC obligations for ministers. Scotland used the due regard model as a first step before moving towards fuller incorporation of the international treaty obligations. In Canada, the Accessible Canada Act came into force in 2019, and the overarching goal of the ACA was to realise a barrier-free Canada by 2040. The legislation benefits all Canadians, especially people with disabilities, through proactive identification and removal and prevention of barriers to accessibility in 7 key areas. The ACA requires regulated entities to prepare and publish accessibility plans, set up feedback processes and report openly on the progress. So the ACA gives the authority to create and enforce accessibility regulations. So those are 2 examples, and the third one I was going to highlight was the New Zealand. While New Zealand hasn't fully incorporated the UNCRPD into domestic law, its public bodies routinely reference the duty to give due consideration to the UNCRPD obligations in policy making, particularly in areas such as inclusive education, transport and accessibility. So they established an independent monitoring mechanism under Article 33 to ensure government accountability. And the Ministry of Disabled People, I'm not sure the pronunciation of this, but I think it's Wakihaha, formed in 2022 to embed disability rights across the government of New Zealand. So there's 3 examples there of various types, and due regard was an element of those as well.
Yeah. Sorry, just to follow up that, Chair. And just in terms of, obviously, a lot of those examples appear to be the stepping stone approach that you had previously mentioned. Is there anything you envisage within your legislation, Danny, that would underpin ensuring that, obviously, we're not at the place of a private member having to take forward private member legislation again, and the department is being more proactive in terms of taking those next steps?
Not in the current wording of it, but certainly, that will be something under consideration. And I'm sure within the progress of the bill through its legislative stages, that would be something that could be brought out and discussed to have that lever to progress at a future stage.
Appreciate that. Thanks, Danny. Thanks, Chair.
Thank you. So listen, Danny, I think we've been one quick one just for me, and maybe Kelly touched on it, but I may have missed on picking up. But was there any consideration given to the potential of a commission or to oversee in terms of due regard? Has any of that came up in your considerations?
It wasn't something I think that came back in any of the consultation responses. I think it was something that we'd considered early on and initially, and I think it will be something that we'll have further consideration as the bill progresses.
Okay, well listen, thank you, and I have to say I do agree strongly with your view there that we are out of sync and we're very far behind, and I think it's very useful, this work, in terms of redressing that. We heard, I think, in the early stages of this committee, I think it was the Equality Commission, that there's a huge need for an overarching disability legislation, and that need will remain even after your work, but that's not to say that the work you're doing is not a useful step along that path. And absolutely, we should be trailblazing and leading. There's no reason why we wouldn't be leading on these islands, never mind across the rest of the world. And in fact, in a place that's so fond of beacons, we should, I believe, become a beacon for human rights and light the way. And we shouldn't be written. I would love to see not only this legislation and other legislation, but even a Bill of Rights. And I think that's an important workforce for the future. But I thank you for your contribution to this today, for your information you've given members, and you have there's a couple of things there that you have agreed you'll send on to members, and that's all very useful. But just wish you well as you go through it. It is a big undertaking, and appreciate it, and thank you for your attendance. Thank you for your written submission and for your taking the members' questions here today. Much appreciated.
Thank you very much, Chair.
Thank you.
Members.
Okay, thank you. Members, any further actions or follow-ups that members want to note in relation to that item? Okay, well listen, before I move to the next item, we need a couple of minutes just to set up all the information, so maybe take a short comfort break there and come back in 5 minutes again. Thank you.
Yeah. Party maker.
Just wait for the signal.
Okay, thank you, members. So we're now resuming our meeting at agenda item 8, which is a briefing by Raise on the comparison of disability legislative frameworks across England, Scotland, Wales and the South of Ireland, the Republic of Ireland, which is the updated and reissued briefing paper for this agenda item is in your table papers there, members. We will welcome now the following official from Raise to the meeting, Michael Greig. Is that correct? Greig, okay. Michael, thank you, and could I invite you to brief on the paper and then we'll get to questions from members. Thank you.
Great, thank you, Chair, and hello members, and thank you for the opportunity to come and speak to you today about the disability legislation that is in place in Great Britain and the Republic of Ireland. Unsurprisingly, there is a lot of content when it comes to this particular subject. There is an extensive array of legislation covering disability in Great Britain and the Republic of Ireland, with the rights and protections for disabled people dispersed across a wide range of sources. Therefore, I won't be going into everything that I've covered in the briefing paper. The intention here is really to draw your attention to the main pieces of legislation and some policies and frameworks that other administrations have introduced around disability. So with that in mind today, I'll be discussing the relevant international treaties and wider UK legislation. Obviously, Danny just gave his briefing about the UNCRPD, so I'll be quite brief there. An overview of disability legislation across Great Britain, then the relevant legislation relating to disability in the Republic of Ireland. I know the Chair just mentioned it, but I'd just briefly like to draw your attention to the revision made on page 10 of the briefing paper, which is just the inclusion of section 15, disability arising from, or discrimination arising from disability. That's the only change that was made there. Just a brief bit of context. This briefing paper was developed in response to the Committee for Communities Evidence session on disability law reform in Northern Ireland that was held with the Equality Commission for Northern Ireland back in November 2024. The Equality Commission outlined several recommendations that would bring Northern Ireland's disability legislation in line with Great Britain and with international best practice. Just a quick point of clarification, the briefing paper does not cover the process of how the legislation or a particular policy was implemented, nor the impact those pieces of legislation have on disabled people. The cost of implementing any legislation and subsequent measures is also not discussed. It's really just focused on what the legislation itself was intended to do. So, just moving on to international treaties and domestic legislation in the wider UK. Any new legislation, bills and policy introduced across the UK, including Northern Ireland, that covers disability must take these international treaties and UK-wide legislation into consideration. Again, very briefly on the UNCRPD, the UK is a signatory to the UNCRPD, an international treaty that identifies the rights of disabled people and places certain obligations on the UK government to promote, protect and ensure those rights. As Brian mentioned a moment ago, the Convention is not incorporated directly into domestic law but is given effect through separate legislation. In Great Britain, this is the Equality Act 2010, as I'll discuss in a moment. There is the European Convention on Human Rights. The role of the ECHR is to encourage and support member states to implement the necessary measures and changes to protect the rights of persons with disabilities. Article 2 of the Windsor Framework, it places two legal obligations on the UK. Firstly, the UK must ensure that there is no diminution of certain rights and equality protections in Northern Ireland as a result of the UK leaving the EU. Secondly, the UK makes a specific commitment towards maintaining a dynamic alignment with certain EU anti-discrimination directives. Essentially, if EU directives are updated, domestic law in Northern Ireland may also need to be updated to ensure that minimum standards are met. Lastly, there's some domestic legislation in the UK, which is the Human Rights Act and the Employment Rights Act. These cover the whole of the UK. The Human Rights Act requires all public bodies to act in a way that protect a person's human rights, and the Employment Rights Act includes provisions that indirectly relate to the rights of disabled people, aka employment or sickness in employment. So the main piece of legislation that I wanted to highlight today is the Equality Act 2010. It provides protections against discrimination in the workplace and across wider society in Great Britain. The Act combined 9 previously separate pieces of legislation into one. This was an intention to make the law easier to understand and means the Act is a single reference point for definitions and guidance around equality. The Act strengthened the law in a number of areas, including placing a duty on public bodies to consider their socio-economic disadvantage when making decisions, extending the circumstances where a person is protected against discrimination and victimisation because of a protected characteristic, which I'll get to in a second, created a duty on public bodies to consider how their policies, programmes and service delivery affect people with protected characteristics, and allow organisations to take positive action to enable existing potential employees or customers to overcome or minimise a disadvantage arising from a protected characteristic. Just to get into some of the key sections of the Act makes several provisions around disability. This included the creation of 9 protected characteristics, disability being one of those protected characteristics. It introduced an update on the definition of disability. An individual has a disability if they have, and I quote, a physical or mental impairment that has a substantial and long-term negative effect on their ability to do normal daily activities. In this case, substantial means it takes longer than it would usually do to complete a daily task, and long-term is defined as an impairment lasting for 12 months or more. It provides an overarching framework against discrimination. Discrimination includes direct discrimination, discrimination arising from disability, and indirect discrimination. There is a duty to make adjustments. Adjustments can include changes to policies and practices, the built environment, such as disability access, and auxiliary aids and services. The Act provides protection against victimisation. And the Act makes it more difficult for disabled people to be unfairly screened out when they're applying for jobs, and restricts the circumstances where employers can ask for information that relate to disability and health. This provision is really intended to address the disincentive impact that probing questions can have about health when disabled people apply for jobs. Lastly, there's the public sector equality duty. This requires all public bodies to consider all individuals when carrying out their day-to-day work. Public bodies are required to publish relevant and proportionate information that demonstrates their compliance with the duty. It's not mentioned on this slide, but just before moving on, I want to point out to the committee that a section was included in the briefing paper just outlining the UK government's proposed legislative changes in the Pathways to Work Green Paper. The proposed amendments as they relate to disability include the scrapping of the workplace capability assessment, an intention to expand access to statutory sick pay, flexible working, and introducing mandatory reporting on disability gaps for large firms, changes to personal independence payments, or PIP. The intention is that PIP will be more focused on individuals with high levels of need, and establishing the principle that trying work does not lead to a reassessment of benefits or a change in circumstances. So I'll just move on to England now. While, again, the Equality Act is the main piece of legislation that covers disability protections, there are a few others just to be aware of. The Children and Families Act, this is intended to give parents greater control of how support is provided to disabled children. The Care Act, this introduces guidance that includes the well-being principle, where local authorities must promote the well-being of the adult when carrying out their care-related services. It also outlines the requirement for local authorities to establish a safeguarding adults board, and really this is intended to protect adults who are at risk of neglect or abuse but can't look after themselves. There is the Mental Capacity Act, and fundamentally this governs the decision-making process for adults who either lose decision-making capacity at some point in their lives or who have an incapacitating condition since birth. Moving on to Scotland. The power to legislate on equality was devolved to Scotland under the Scotland Act 2016. This Act gives the Scottish Government the ability to introduce protections and requirements that supplement but do not modify the Equality Act. The Equality Act also introduced specific schedules for Scotland. Scottish public authorities must consider the need to eliminate unlawful discrimination, advance equality of opportunity, and foster good relations. The Scottish Government set out its own delivery plan in 2015, titled A Fairer Scotland for Disabled People, to implement the UNCRPD. The plan is based on the social model of disability. I'll get into the two models on the next slide, but this included ambitions to promote and enable independent living, enable participation in employment and education, ensure that the wider built environment is more accessible, and essentially ensure that disabled people can participate as active citizens in all aspects of daily life. There are a range of bills and legislative instruments. in Scotland that mention disabled people. I won't go into each in detail. You can find full details of those in the briefing paper, but two that I just want to briefly draw your attention to is the Adults with Incapacity Scotland Act. This is similar to the Mental Capacity Act in England and introduces a system for safeguarding and welfare to enable people with disabilities to make decisions.
Just a second, Michael. We might need to pause a wee second as we issue with the broadcasting. And so we've lost the presentation on screen. Just to say to members, you have the same presentation in your packs there as well. And we're back on. Can I just check, is that dealt with the other issue? Or do you still need to further check that? Yeah. Carry on. All right, go ahead then, Michael.
Continue. It is all in the packs as well.
Yeah. We're back. We're back.
Right, there we go.
Thank you.
I was talking about the Social Care Self-Directed Support Act. This makes legislative provisions relating to care and support for those who need it, including disabled people, and really this is about giving people freedom of choice and a say in the support that they receive. I mentioned I would do it a second ago, so here's a slide on the medical and the social models of disability. The medical model looks at a person's impairment first, where the impairment is the cause of the disabled people being unable to access goods and services or being unable to access or participate fully in society. It focuses on the biomedical perception of disability, aka what is the impairment of the individual from a biological perspective. The Equality Act 2010 follows the medical model of disability. For example, definitions of disability discrimination focus on what a person is unable to do because of their impairment. The social model, on the other hand, is the understanding that disability is something created by society, where disabled people face barriers that stop them from taking part in society in the same way as a non-disabled person. Disability is something that a person experiences with wider society failing to take account of that disability due to certain barriers. And those barriers can include physical barriers, societal and attitudinal barriers, institutional and communication. The inference here is that society should work to reduce these barriers to enable the full participation of disabled people. As Danny mentioned or was talking about, the UNCRPD follows the social model of disability, and the Welsh and Scottish governments have stated an intention to move towards that model as well. Just to point out, I am not making any judgment here over which model is necessarily better than the other one. Moving on to Wales. The Welsh Government has the power to legislate on equality and disability issues through the Government of Wales Act 2006. It also has devolved responsibility to implement the UNCRPD and has specific schedules under the Equality Act. In 2021, the Welsh Government made their commitment to incorporate the UNCRPD into Welsh law. The latest policy framework is from 2019 Action on Disability. It focuses more on policies and strategic actions rather than an intention to introduce any new legislation, but intends to work towards removing or reducing some of the barriers faced by disabled people. The Equality Act enables Welsh ministers to impose specific uncertain duties on Welsh public bodies. The Welsh specific equality duties require those public authorities to develop equality objectives, conduct impact assessments, and identify gaps in pay, for example, disability pay gaps. Some devolved Welsh legislation includes the Social Services and Wellbeing Act. This brings together the duties and functions of Welsh local authorities, requiring them to improve the well-being of people in care and support. And the Wellbeing of Future Generations Act aims to improve the social, economic, environmental and cultural well-being of Wales. This includes the intention to eliminate the disability pay gap by 2050. Just briefly as well, and I know this was talked about previously, I mentioned in the briefing paper that the 2024 UN report found that the UK was not doing enough to consistently apply the UNCRPD. The report concluded that no significant progress had been made concerning the situation of people with disabilities, and in fact there have been signs of regression in the standards and principles of the Convention. I've added some of the concerns that were raised onto the slide. For example, insufficient national consistency in meeting the obligations of the Convention. PIP and adult disability payments were identified in 2024 as insufficient to cover the extra cost of living with disabilities. There is a continued lack of community-based support, and there is an increased use of automation and AI tools to monitor disabled people's bank accounts. It's also worth noting that the report raised the fact that the number of disabled people committing suicide is on the rise. Lastly, I'll cover disability legislation in the Republic. Disability legislation is aimed at promoting the equality, accessibility and rights of disabled people. The Republic signed the UNCRPD in 2007 and ratified it in 2018. As with the UK, the rights set out in the UNCRPD are given effect through domestic legislation. The Republic delivered their first report on the progress made in implementing the UNCRPD in 2021, and this set out some of the policy frameworks that they've introduced, including the Comprehensive Employment Strategy for People with Disabilities and the National Disability Inclusion Strategy. The Equal Status Acts are intended to promote equality, prohibit certain types of discrimination, prohibit sexual harassment and victimisation, and require reasonable accommodations be made for disabled people. The grounds for discrimination included in the Act includes disability. The Acts prohibit certain types of discrimination, including direct discrimination, discrimination by association, indirect discrimination, and procuring discrimination. This basically means that it's an offence to procure another person to engage in discrimination. The Acts introduce the need to make reasonable accommodations for disabled people, but this, when reasonability is said, it depends upon the size and the resources that are available to that organisation to make those adjustments. Final slide, as you'll be glad to hear. The Employment Equality Acts are similar to the Equal Status Acts, but specifically deal with protecting individuals from certain kinds of discrimination, harassment and sexual harassment within the workplace. The Disability Act 2005 places a statutory obligation on public services to support access to services and facilities for disabled people, and the European Accessibility Act provides new standards on accessibility covering a range of products and services. The aim of this act is to improve the functioning of the internal market for accessible products and services by removing some of the barriers that are created by a divergence within some of the member states. It really covers items such as computers, smartphones, ATM machines, that kind of thing, and is primarily intended to benefit disabled people and the elderly. There's a couple of other legislation that's mentioned there in the final bullet point. Again, they're all detailed in the briefing paper. I don't have a slide on the Republic of Ireland's performance on disability rights as I did with the UK. This is not to say that there are no issues with disability protections and legislation in the Republic. The Irish government submitted its first report to the UN Committee on the Rights of Persons with Disabilities in 2021. As far as I am aware, there is currently no date set on when the review of that report will be published, but criticisms from other sources, such as the National Disability Authority's report in 2023, stated that work was still needed to improve access to voter information and encourage the participation of disabled people in the electoral process. Chair and members, that's the end of my briefing. If you have any questions, I will do my level best to answer them.
Thank you, Michael. That's very useful, and thank you for the paper and your presentation here today. Very useful, and I suppose one of the things that it highlights is, and we heard from Danny Donnelly earlier in the previous session about his members' bill that would bring in, introduce a statutory duty on public authorities to have due regard to UNCRPD. Yep. The jurisdictions across these islands, is very clear from your presentation, have very differing legislative relationships with the Convention. Do you feel that any of the jurisdictions have fully and unequivocally committed to the Convention?
I mean, I don't want to really give a personal opinion on that. I know that each jurisdiction has its own independent monitoring mechanism about the progress that they have made in terms of implementing the recommendations of the UNCRPD. Just off the top of my head, I can't think about how it's split between each jurisdiction and what the report findings were for those jurisdictions, but if the committee is happy, I can certainly come back to you with further information on that. Yeah, I think that will be useful, and I appreciate that you're not given, or you don't wish to get into the person, but you're obviously extremely well versed in this, so I appreciate that expertise in that sense. You do cite a submission from the Equality Commission to the Committee for the Executive Office Inquiry and a specific recommendation that provisions within the current disability legislation should be harmonised and simplified where possible. And this committee has heard that directly from the Equality Commission ourselves in the early days of this mandate. Recent history would suggest that the very opposite has been happening to some extent in recent years, and there's a fracturing and a diversity of approach. Would you have any thoughts in relation to how the system can be as sensitive to the specific challenges here as we move forward? again, I wouldn't really want to give like my thoughts on how that process could be taken forward.
I sense it'd be interesting, but I answer.
I mean, I suppose the main area, and I think the Equality Commission spoke on this in the briefing in their report that they submitted about how that could be taken forward, because I do know that there are some thoughts around like co-production and things like that as to how this legislation is harmonised and simplified. So I would say that they would probably be best placed to comment on that particular point.
Okay, thank you very much, Michael. I'm going to go to members then. So we have Kelly and then I have Brian.
Thank you very much, Michael. You talked about the other jurisdictions in GB have monitoring mechanisms. Do you know how they work? Is it an independent panel or is it a committee, related to that?
I think they're independent monitoring mechanisms, because there's the Equality Commission for Scotland, the Equality Commission for Wales, and I can't quite remember if there's one specifically for England, and obviously in Northern Ireland there's the Commission for Human Rights as well, so they come together to form that sort of independent monitoring mechanism. I'm not 100% sure quite how it's arrayed in each of the other jurisdictions, but again, I can certainly come back and just give you a definitive answer as to how that is put together.
It'd be quite useful because unfortunately here we still have departments who could be bringing forward different aspects of support for people with disabilities, but it's all silo. It'd be good to find out, so if we have a body here in Northern Ireland that all departments can report to, then it cuts out that breakdown between committees. Yeah, 'cause it causes problems for scrutiny here. Yeah.
There's a strong theme across a range of issues.
Yeah. That would be useful, yeah.
Thank you, Kelly. Brian.
Thank you, Chair. Thank you for your paper. Can you clarify what is meant by signing, ratifying and incorporating?
Yeah. A good example there is in the Republic of Ireland, where they signed it in, 2008, and then ratified it several years later. Signing basically commits them to incorporate the recommendations of the UNCRPD. The reason there was a 10 or so year delay between them signing and ratifying it is because the Irish government wanted to update and ensure that their domestic legislation was in line with some of the recommendations that were made by the UNCRPD, so therefore there was the sort of time difference there. The ratifying of the treaty essentially brought it into effect, as in they are now fully committed to upholding the treaty itself.
Right. But you said signing commits them to incorporating it into law, but the UK has signed and ratified, but it's not directly incorporated in UK law. It's obviously it's given effect through the Equality Act. So I'm just trying to understand. So a lot of countries have signed it. So ratifying is when you bring it into legislation.
So basically,
in some give it effect through legislation. Is that
so
right?
As an international treaty, it doesn't have provisions of law that say you must do X, Y, and Z. Yes. It's basically saying we recommend
principles
that you do.
Yeah,
principles and recommendations and things like that. So it is up to a country to bring those recommendations into effect. It's really why that while the UK can be a signatory to the UNCRPD and has ratified it, it is still not meeting certain obligations that it made to the UNCRPD. So you can be signed up to it, you can have ratified it, but you're still not meeting its obligations.
And I must have a look at the actual wording of the UNCRPD. So for Wales, I think, was Wales the only one in your presentation that is intending to directly incorporate it?
Scotland as well. They're planning on doing it as well. Yeah,
right.
Yeah, so they've introduced some policies and frameworks in Scotland also to say that we are going to be following the social model that's recommended by the UNCRPD. The reason England is more following the medical model that isn't covered by the UNCRPD is because the Equality or the Equalities Act follows certain definitions of a disabled person. But it's Wales and Scotland who are planning on or have their own sort of separate implementation.
And you think that their intention would be to have legislation which directly refers to the UNCRPD?
I'm not sure what their intention is as to,
Oh, no, just understanding the UK has ratified it by bringing it into effect through the Equality Act. Well, effectively brought it into effect, right? Whereas some want to actually incorporate the UNCRPD directly in its wording.
Yeah, so the sort of various jurisdictions have their own flexibility in how they want to do it. Like Scotland and Wales have their own, essentially it's just they've given that flexibility to incorporate the recommendations of the UNCRPD on how they see fit, essentially.
Okay, thank you.
Okay.
Thank you, Chair.
Thank you, Brian, and thank you, Michael. And I suppose one occurs to me, and this is probably outside of the brief, so I will fully understand if you don't have a ready question. But I am curious to know, in your work, did you come across, are there any, and this was specific to these jurisdictions and these islands, but are there any countries out there beyond these islands who would be seen to have fully implemented UNCRPD, or who would be seen to be leading on implementation? And are there?
Yeah, you kind of said in your question, I'm really not sure on that point, but if there are sort of specific jurisdictions that you're interested in, or if there is just a scan of other countries that are sort of leading best practice in terms of the implementation, then yeah, I could take that forward.
I would love to see a scan just to see if there's somewhere that we could. I don't have anywhere particular in mind. I suspect some of the Scandinavian countries may be further ahead, but you never know. But I would be curious to know if there are areas that we could look to as leading on this, and that's in the context of the discussion we had earlier. There's no reason why we shouldn't be leading ourselves, and that's where I'd like to be. But listen, thank you for that. I don't think there's anything further from members at this stage. Thanks a million for your input, Michael, and appreciate your appearance here today. Thank you.
Thanks, Michael.
Okay.
Okay, thanks, members. Any follow-up actions, Kelly?
Just going to say on that monitoring piece, it would be good just to find out how the monitoring works for each of the areas. Yeah. Just if it's
Chair, before Michael goes, sorry, could I cut across, Kelly? I did want to ask that, maybe it ties in with your question. I mean, does that UN committee basically see itself as having a role then to continuously monitor? So does it do regular? I know you referred to a report in 2024.
Yeah, so countries are obligated to submit a report every 5 years,
right,
to the UN committee. But the timings on when the committee then comes back with their review can change. There isn't a sort of set reporting period on that.
Right. Just when they feel they have something to say.
Possibly, yeah.
Right. Okay, thank you, Chair. Sorry, Kelly.
Thank you. Thank you.
Well, it's just to see if we could get a bit of research on how monitoring is done at country level in England, Scotland.
And that might tie in with my question, right? So if we could ask for a further piece on that, members content, we seek that.
Useful.
Yeah. Okay.
No, sorry, no, we are.
Yeah. Okay. Melissa, were you looking something there? No.
No.
Okay. Okay, so listen, members, thank you for that then, and we're moving on then to agenda item 9. And this is a departmental briefing on intermediate rent. So members, the papers for this agenda item start at page 232. And a background, previously published raised paper on financial transactions capital was circulated to members yesterday. So I'd now like to welcome the following departmental officials to the meeting. So we're joined by David Polley, Maryann Dempsey, and we're also joined by Jon Anderson from Maple and May Ltd. So David, I would like to invite you to make some opening remarks, and then we'll move to questions from members. Thank you.
Certainly, Chair. Thank you for your invitation today. So I just want to talk through what we've done on intermediate rent and our plans for intermediate rent going forward. So I'm joined by Maryann Dempsey, who works in the department and is the project director of intermediate rent, and Jon Anderson, who works in Maple and May, the organisation selected to act as the intermediate rent operator. So just to start off with a wee bit about what intermediate rent is and isn't. Intermediate rent is an innovative approach to the delivery of affordable housing for our housing market. It's important to be clear that intermediate rent is an affordable private rented product. The tenancies on offer are private rented tenancies and not social tenancies, and this means that the rights and obligations of private tenancies will apply both to tenants and to Maple and May as the landlord. The intermediate rent policy was published in March 2023 and it will apply to these tenancies, and this will provide some additional protections for intermediate rent tenants, such as better security of tenure, enhanced affordability and the availability of support services and things like that. A key aspect of the policy is the income eligibility threshold, which will target these homes to lower income households who are more vulnerable to rental affordability issues. Income thresholds have been initially set at £30,000 net for single adult households and £40,000 net for joint income households. And we think that intermediate rent can make a real difference for households. For example, households who want to rent but are struggling with affordability and access to the private rented sector, households who wish to save for a deposit to access low-cost home ownership, or households who are waiting for a social house allocation and wish to access an affordable rented home in the meantime. So rents will be discounted by at least 20% when compared to local open market rents for property of a similar size and type, and families can stay in their intermediate rent home for longer. 5-year tenancies will be offered to successful applicants, although they can, if they wish, opt for a shorter term. And at the end of the first 5-year tenancy, there's the option to renew where both the tenant and the operator is happy to. And these longer tenancies can help people put down roots in a community, to live closer to their place of work or education, and to have the reassurance they can stay there for the longer term. Intermediate rent can deliver better quality homes as well, with more responsive maintenance than some of the other homes in the private rented sector. It will also provide additional support services to tenants, either in-house or through signposting to dedicated support services, and this can help tenants break down some of the barriers they face in maintaining a tenancy. So the application process for intermediate rent tenancy will operate very differently from the process that the members will be familiar with for social housing. There's no points awarded, there will not be an allocation process or waiting list similar to the one used for social housing. There will of course be no restriction on somebody who's on the social housing waiting list applying for an intermediate rent home, and no requirement for them to remove themselves from the waiting list if they are successful in getting an intermediate rent tenancy. Homes will, once available, be advertised and let in a similar fashion to other private rented properties. And from our experience and how this has worked in other places, there could be little doubt that demand for intermediate rent housing will exceed what we can provide initially, especially with the first few houses, the first 300 houses. So Maple and May will develop a fair and transparent letting policy, which will be shared with the department prior to the award of funding. So I talked a wee bit about the policy and what intermediate rent is. So the next step for the department was to get some intermediate rent houses. So the research indicated that to be viable, delivery, it should be scalable, and that's why we're moving forward with delivery through a single operator model. This can allow us to scale up delivery and to allow us to take a test and learn approach and make adjustments that we need. We know from the research that there's some locations where the gap between affordable social rents and open market private rents is not so severe, and it's recognised therefore that intermediate rent will not work as a product in every location. We launched a competition for funding to act as an intermediate rent operator, and that was open for applications during the summer of 2024. The competition allowed us to identify a suitably experienced organisation with good financial standing and a track record of housing delivery. And it was open for applications to any organisations who met the eligibility criteria, which included that they can be awarded an FTC loan, have a credible track record in the delivery of housing and property management within the Northern Ireland housing market, and are legally permitted to offer private tenancies. So just in this last point, it's quite key, because intermediate rent is a form of private tenancy, and some organisations cannot directly deliver a private tenancy, a private rented tenancy. For example, dwellings which are part of the estate of a housing association cannot be private tenancies, and the same applies to the Housing Executive, Northern Ireland Departments and some others. But private subsidiaries of housing associations are not impacted by that legislation in the private tenancies order. Competition applications were assessed in October 2024 following confirmation checks on eligibility and assessment of the financial proposals. Maple and May Ltd, which is a wholly owned subsidiary of Choice Housing Ireland, was selected as the highest scoring applicant to move forward to the next stage. So John's here from Maple and May. Maple and May is an existing private landlord whose focus is on raising standards in the private rented sector and raising revenues to help support those in acute housing need. Work continues to agree the shape of the final delivery pipeline and the funding arrangements supported by Strategic Investment Board, and we expect to finalise these later in the year. So at the minute, because of these ongoing discussions, we can't be precise about the locations, the delivery schedule and the quantum of funding just yet, but we can keep the committee updated as we go along. After the competition for funding, the department intends to fund Maple and May to support the delivery of 300 new build intermediate rent homes over the next few years. And that would be FTC, and we know that FTC works well for affordable housing. It's worked very well for some time in delivering shared ownership homes via co-ownership, and it's used to deliver intermediate rent homes for rent. It's just a logical extension of this, but also crucially using FTC low interest loans means that we can maximise the delivery of affordable housing without impacting on the capital funding available for the delivery of social housing. So it's not in competition with building social housing. We can also lever in substantial private finance, with Maple and May are going to provide a 15% capital contribution to the development costs on top of our loan, which means that we should get more bang for our buck. So we expect that delivery will be spread across Northern Ireland where there's an intermediate rent need and where the gap between social rent and market rents are highest. The sites have provisionally been identified in 8 different local government districts, and we will confirm the details later in the year once the delivery pipeline is confirmed. And in terms of what we're doing going forward, our next steps, before a formal funding offer can be made and accepted, we have to, Maple and May, as the operator, will confirm their delivery and funding proposals and do their operating business case. Now we use that as the basis for a full business case by the department to secure the FTC funding. Work has also commenced to prepare the legal documentation to set out the conditions of our loan to Maple and May, and that's going to be completed over the next few months. So subject to those budgets being available and approval, it's our aim to have a funding package agreed by the spring of 2026 and the first homes to follow within 12 months after that. So the task for Maple and May as they set this up is going to be challenging. It's bringing a brand new product onto your housing market as well as getting 300 houses. Once these homes are available to let, tenancies will be advertised to eligible lower income households and allowing them to apply for these high quality, stable and secure homes at a more affordable level of rent. The last point I want to make is that delivering intermediate housing for rent isn't necessarily restricted to just Maple and May. We have committed to exploring how we can further grow this important affordable housing product in the supply chain and introduce measures which can help deliver more affordable homes for rent. The revised definition of affordable housing for planning purposes in the SPPS now includes intermediate housing for rent as a form of affordable housing, and broadening out this definition of affordable housing creates opportunities which didn't previously exist and act as levers to support council planners in increasing the volume of affordable homes, so we might be able to get some windfall intermediate rent through local development plan planning obligations in addition to the ones delivered by Maple and May. So anyone who can comply with the policy and design standards which are online and already in place that already exists can offer intermediate housing for rent whether or not they receive grant from the government or support from the government. So we are continuing to work with a range of partners including housing executive councils, other people in the housing sector to ensure the successful deployment of funded and unfunded or windfall intermediate rent going forward. So I hope this has been useful. I'm happy to take questions.
Yeah, that has been very, very useful, and I have to say, I welcome all initiatives which can see affordable homes being built. I have to say that's the perspective I come at it from initially, so it is interesting, and there's a few things I suppose just to tease out in relation to how this scheme's working, given its relative newness here, and obviously it has been operating in other places, so there should be some information hopefully based on that. But in terms of the application process, can you give a little more detail on that and how that's going to be monitored in the sense of that the applicants, that there's a fair screening? You've said there's no points, so how will the department ensure there's no abuse of that system and that those homes are going to people who genuinely need and merit them?
So this was the first point I'd make, is that we're a wee while away from having to finalise the application process, so I'll ask Maryann to talk about how we're going to monitor that, and then Jon can talk about, because part of the process that actually practically how you do it, Maple and May are going to make a proposal to the department as part of the process of finalising all this, so we haven't actually agreed that yet, but do you want to talk about how we'll monitor it?
Yep, so the policy itself sets out the broad parameters for the application process. Must be fair and transparent, it must be available both digitally and in hard copy, so nobody's disadvantaged in being able to make an application. In terms of eligibility, the eligibility criteria is based around income, so that means that we can target these homes to the households that are financially most in need of them. And David elaborated on the parameters that are set out for single adult household and 2 adult household. So when we hand this over to Maple and May, their application process must take that into account. It must also assess the applicant household's ability to pay the rent. So it was very forcefully put to us during the consultation process and during the co-design process that it's not just as simple as saying how much money comes into the household. You need to take account of what's gone out of the household as well to make sure that people can sustain these tenancies. And again, that's why we majored on the need for tenancy support element as part of delivering these tenancies. Maple and May will be producing the application form and the application process, and that lettings policy, the whole kit and caboodle, will come to the department for endorsement, and Maple and May will be responsible ultimately then for ensuring that the application process follows the policy parameters.
And we will oversee Maple and May's delivery of it to make sure that it does that as we go forward. Do you want to talk a wee bit about your thinking about applications?
Yeah, and we met in the last few days just as a preamble, if you like, to this. So I suppose just to give you a flavour, we have undertaken a number of study visits, both GB and south of the border in Dublin, and there are a range of options. To give you a sense of one of those, seems to be quite commonly used, is that when we were 2/3 or 3/4 the way through a project and the building of that project, we would, advertise and through all the usual channels that these houses were becoming available. We would have a closing date for applications, and anyone could then apply to us. We would screen those applications against our lettings policy, which we will have had approved through the department, and then ultimately we might be left with 60 homes and 100 applications that are eligible, and those, as commonly is the case, then would be drawn from a hat. At that point, a ballot system, if you like. So that's just one example. There are 2 or 3 similar approaches, but as David said at the start, we really need to look into that now over the coming months, and before we get on site, then we'll land that and get approval from the department on a preferred approach.
This is a very important bit, Chair, because they've launched some schemes recently in Dublin, and they've been completely overwhelmed. There have been hundreds of applications for dozens of houses. Now, the first point I think Jon alluded to is that a lot of those are people who earn too much, who would like an affordable, but they don't need an more affordable house. So the screening in other places has taken out a lot of people who would like them but don't need them.
Okay, thank you. Well, listen, we will keep an eye on that and appreciate further information coming through the committee on that. I think it's an interesting scheme and one that, and I understand part of the demand will be out of our hands, and I suspect will be strong indeed. However, one thing that is within our grasp is ensuring that the homes are in the right places, and that they are in areas where homes are needed. So can you outline how the geographical breakdown of 300 homes, and how are they aligned with areas of greatest need? And just before you do that, I do want to say I think it's really interesting, the idea of local councils being able to potentially feed into this process and use some of that. I think that's one to look at. But how are we aligning this process with need?
And we've been working with the place shapers and the housing executive, and they've developed a process. It's part of their overall work that they do around housing need, because it's not just absolute, it's about sizes of houses and types of houses, but it's also about tenures. So they look at social housing need, they also look at intermediate housing need, and they've introduced intermediate housing need for rent, and they've worked out a methodology to bring that into their discussions and with the local plans and the local council planners. I mean, it does. They've done a run through of that on some postcode areas. So one of the things you discussed is, social housing for about common landed areas, which are quite small, but the open market people are more mobile. So the question with this was, well, how mobile will you be for this? And we don't know that because we haven't got it yet. But they did it at a postcode level. So they ran it for one postcode in Belfast, and the whole 300 could be, there was more need for more than 300 in that one postcode area. So the initial says at the start there'll be a lot of unmet need. We just need to get this started and up and running. Their assessment was, if you look at the number of people, so Maryann might remember the numbers better than me from the research, when you look at the number of people who earn the amounts that we're talking about here in the private rented sector, there are tens of thousands in Northern Ireland.
So what steps will be taken to regulate that, given that you could put them all in one postcode area and they will be needed?
Yes.
So how will you ensure that there's fairness out into rural areas and places where housing stresses are?
That was partly how we did the competitions. Maryann knows more about that than me.
Yeah, the competition required applicants to nominate where they would anticipate their pipeline of homes would be, and we mandated that there must be in at least 2 local government districts, and that was based on the research that the department had conducted by the Caish, which indicated that there were 4 local government districts in particular, Belfast City Council, Derry City and Strabane, Ards and North Down, and Lisburn and Castlereagh, which had over 30% of a difference in terms of the cost between private rented rents and social rented rents. So they were the primary areas. Then there's secondary areas where there's between 20 and 30% and so forth. So there's some areas where there's very acute need for an affordable rental product like this, because there's such a gap between the open market rent costs and the social rent costs. Conversely, there's some areas where there will unlikely to ever be a need for this, because private rented costs tend to be lower in some areas, and there isn't such a gap between social rents and private rents. So there are definitely hotspots, And we asked our applicants to maximise that, and Maple and May have done that with the pipeline that's in their application. But there is a fair spread, as David said in his opening remarks. It cuts across 8 local government districts at the present time.
So we asked for at least 2. The research showed there were definitely 4 places where there's a significant gap and this should work. Maple and May had a proposal that said they would put this in 8 different local government areas. So we're very happy with that. It is a good spread.
Yeah, and I think there is, you know, in terms of the 4, there's a clear lack of rural balance. I'd love to know where the area is where the pressures aren't too bad, but I'm not picking up too many of those. But so I think it's something that we will want, and I do welcome the fact that there's maybe more of a spread in terms of the 8. So thanks for that. For now, I'm very conscious this is quite new in a sense, and is developing as we go. So it's one we'd probably want to keep a fairly close watch on and be back to you. But for now, I'm going to go on ahead to members and see where we get in relation to that. So if Kelly, Melissa, and Brian indicating at this stage. So Lana, Kelly, please.
Thank you. The chair's already nicked one of my questions, but can I just check in the model, what's the consideration for the deposit levels for anybody who gets one of these tenancies?
Is there a particular thing around deposits?
So it's the same as any other type of private tenancy, so it's capped at 1 month's rent. But we know that that's a perennial barrier for people entering the private rented sector, so we've included a provision in the policy that people can build up their tenancy deposit over a period of up to 12 months. So they can, rather than having 2 months of rent defined at the start of a tenancy, that they can progress towards that.
A significant number of people in Northern Ireland are unable to get houses because landlords are demanding guarantors. Will this be the same? Because to be honest, there's some very professional people working in our health sector, because they're not from here and don't have a house here or don't have family here, they're excluded from the rental market. Will that be overcome by this?
So the policy requires people to only look for a guarantor in exceptional circumstances. So we're live to the fact that people are coming from other places that possibly don't have connections in Northern Ireland who wouldn't be able to find a guarantor, and that's something that Maple and May are looking at as part of their lettings policy.
I just don't like the idea of grown-up adults being asked to go to mummy and daddy and get a guarantor, honestly. I like to see a community being built. So how will these properties, or are they being built together separately away from others, or how will this fix into mixed tenure?
So looking at the pipeline now, and I know this is probably a little frustrating for members because we're kind of talking in circles, but there is a mix of mixed tenure development for intermediate rent and standalone. But the pipeline would see properties, I don't want to steal John's thunder here, properties being developed in areas where there is already connectivity. So we're not talking about a little encampment of intermediate rent on a top of a hill in Cunyon. We're talking about in well-established communities and where people can put down roots, because that's a key factor in having these longer tenancies. That people know, I can live in this house when my child progresses through school or while I'm in this employment contract or whatever the case may be. So people do feel like they are part of a community and not parachuted into a home.
I think John could maybe add a wee bit, but obviously like Maple and May is the private wing of Choice Housing, and that's a significant developer. So they are part of the development pipeline coming through from Choice Housing and other bits of Maple and May as well. So an example near my house is, well, near here anyway, at Park Avenue, is a Choice development with the Maple and May private rented on the corner, or Lewis Muse near C.S. Lewis Square is another one, where there's...
I'm very familiar with Choice,
Yes.
But
So
it's
those
just
are
my concerns are that there's areas where the type of rent level that you're talking about, people are in private rent and they will be jumping towards this because it's cheaper, but they may not be on the income levels that you're talking about. That's the one concern I have.
I want to talk a wee bit about development and how you're going to mix these in.
Not really then the former question, I suppose.
Yeah, and then what I think about the second.
Oh, right, okay. So, yes, we are very keen within the Choice group then, within which Maple and May sits. We've been doing lots of mixed tenure, and board are very, very keen to keep doing that. So, as a general flavour, the projects that we would be proposing are often that. And it's an area we like, and we see the benefits in terms of community cohesion and all of that. So this very much sits complementary to our social housing programme within the wider group, and mixed tenure and sustainable communities and all of that as a key aim. So I'll maybe pass back to the guys here if they've had a chance to think of the second question.
Well, I mean, we're very happy that Maple and May is an established mixed tenure developer and has a substantial development pipeline already of other houses that it's building, and is already building within that ones which are rented. So we're very happy from that point of view. And so yeah, I mean, you asked about income levels. So there's two aspects to that. The first thing is that it wouldn't be fair to rent a house to somebody who can't afford to pay it. So part of it is going to be about making sure. And there is a group of people who should be in social. They should be in social housing. And we're not trying to fob them off with something which doesn't suit them. I mean, there are people who should be in social housing with high social housing need, and that's not necessarily for that sort of group. There is a group maybe who would like social housing that we can see this could work for, you know. But there are people who need, and I completely understand that, and we don't want you to take anything away from social housing. We're still talking about ramping up to over 2,000 social houses a year, so that's all. These things are happening together. And the second thing is about the upper end of it. You know, this is affordable housing, subsidised by the government. It's for people whose housing needs aren't going to be met by the open market, so there has to be an eligibility criteria around income. So we've said 30 and 40. Now that's net, so that's net of tax. So that
I'm just worried because there are people who are currently getting housing benefit in private homes that are paying £1,000 a month for their rent. You know, and that poverty level is.
You would still be able to apply for housing benefit if you're living in one of these houses. They're private tenancies, so your rent will go down. Now, your housing benefit, if you earn £30,000, your housing benefit is dynamic with that. The other thing is, in terms of, you know, I know in other places, we say it's 80%. And 80% of a flat in London can be £3,000 a month or something like that, right? But we've said that it should be about 30%. It shouldn't be more than 30% of your income, because that would be defined as affordable. So there is actually a hard cap on it for single person and for couples. It has to be 30% of your income. If you earn, so a couple 40%, well 30% of their income, that's what the rent is. So there's a hard cap on it. And the rents are lower. I mean, when you look at what the numbers are for that, which I can't remember off the top of my head, they're lower than average rents, and we don't want them all up at that. I mean, they're not all going to be up at that. That's
just on that, hopefully we've learned from the housing executive, and John, you might be able to do this. If there's a cap on the rent of the area and you have to pay back FTC or wherever you get your other 15% from, where does the break come? You know, is it maintenance levels have to be reduced? You know, I'm just concerned about the organisation, because the housing executive of having basically a rent cap has meant that they haven't had enough investment to put into their maintenance. Well, are you concerned in any way, or is your figures working out for this?
Pretty much where you finished. The figures are working out.
Okay.
There's lots in that, and there's lots of accountants involved across SIB and for ourselves, and a very, very detailed 25-year financial model. And the outworkings of that is that the model works. It's you know, it just works.
Choice isn't going to do this if it's going to pull the organisation down after it, and we aren't going to lend money to an organisation that can't do it properly. So we want to check that. There is, I mean, in terms of rent increases, there's a mechanism around rent increases. The issue with the housing executive, obviously, like, there was a 4-year rent freeze, and there's been periodic also rent freezes previous to that. So that's sort of left their rent lower than it should be. Rents work cumulatively. You know, if you have a rent freeze this year, you lose money for every year into the future. Do you want to talk about that?
So just to pick up on the point of the investment, quality is a real key aspect of this. It's not just about making these cheaper, it's making these good quality, more secure, better supported. So we asked Maple and May to build into their projections sufficient funding to make sure that properties stay in top condition and start in top condition. In terms of how the rents are set themselves, there's certain safeguards within the policy. So because it's a private rented tenancy, rents can only be changed once in every 12-month period in line with the law. There's a maximum then of CPI plus 1% or 5%, so people know that my rent isn't going to increase any more than that, but it doesn't have to increase up to the threshold, and we'll be asking Maple and May to come to us each year before they set their new rents to explain why the rents have to be set in that way. But we are alive to the fact that we want these houses to be good quality, to not be ridden with damp, to not be needing repairs constantly, so we need to make sure we have the money to invest in those.
My final question, Chair, is it's about the balance of the use of FTC. So we have over 47,000 households in waiting lists for social housing, and we now have this model coming through. What's the figures difference between people who fall into a waiting list for what would be this affordable intermediate rent scheme, and will the department ensure that the FTC, the 2,000 houses a year, let's face it, it's not enough to meet what we need at the minute. I'm just concerned that there could be an imbalance looking for FTC for a product that certainly there's a need in the market, but there's a massive hole sitting over here on social housing.
As I said in my introduction, we've decided to use FTC deliberately not to compete with the social housing development programme. It's our primary focus is on trying to increase output of the social housing development programme, and you'll have all seen the discussions about that. I mean, that's a programme for government target. You can't get any higher than that. You've been in this committee for a while, and you've worked with this on housing for a while. You've known that for years what we really wanted was a programme for government target, because that means that an executive housing supply strategy with these things in it, because that means that, going forward, because the housing associations need security, they need to know where they're going. It takes a very long time to build a house. You have to find the land, get the planning. It takes 5, 6, 7 years to build before a person gets handed the keys. We need a long-term vision over that. So we've got those things in the last year, and we've been working, as you know, towards those things for
it's a bit low all the same.
We've got a PFG target that is moving us towards the 33,000 over 15 years. Which is going to be transformative. It is going to be transformative. Well, much more than we did before. But we designed this to complement that. So when you look at our housing supply strategy, we talk about 100,000 houses, a third of them social. And these are not in that 33,000. These are additional to that. So, and we want, that's the first objective, is to bring in other things as well. So you've got 33,000 socially, you've got affordable co-ownership, a third of which is going to be new build. And then you've also got this, which we want to scale up, 300, as we said. It's not going to touch the sides of who's going to come and ask for it when we open the first scheme, and we're going to learn so much about it in the first 300, and we'll get better about it, but we need to scale it up. So that 100,000, we're looking to substantially the amount of affordable housing, increase the amount of affordable housing, trying to rebalance it. When you look at the overall housing stock, we're sitting at 12-13% social. We want to be up higher than that. We're sitting at a certain amount of affordable, we want to be up higher than that, because there's a lot of non-affordable housing in the housing stocks. We need to rebalance it. So the next 15 years we see as a period of rebalancing. So we're very happy with where we are strategically, but we've designed this specifically not to compete.
What's the target in terms of rebalancing? What percentage would you like to work towards?
We haven't got a target, but I mean, if we do 33,000 houses on top of what we have, if you take away a few that we're going to lose, then that sort of, it depends how many houses. That's a difficult one for me to answer without a calculator.
Okay. Okay, well listen, maybe
on the housing executive selling off their stock would be a start. Yeah. But yeah.
So I'm going to Melissa Liddahall.
Thank you. Well, probably near enough everything has been asked that I was actually thinking on. But I noticed just in your presentation that you said that you had covered 8 council districts. Are you referring there to council areas out of the 11 councils that we have entirely? What are the 3 councils that you're not involved in then?
This is not quite finalised. I would give the game away the ones that are not. There are ones where there's not much difference between, well, there's 2 aspects to it. Firstly, there's whether or not Choice had pipeline, because they're on a competition. So we've done really well, just spread out. And the other ones is that difference between social rents and private rents, which is really very close in some places. So it'll be the places with the lowest, it's the places with the lowest private rents.
But this is only a point in time, it's not that we have an ambition not to have properties, intermediate rent properties in those 3 council areas. It's just that the pipeline that Mabel and May came forward with covered 8. This is the first phase. We are anticipating that this will proceed as we expect. The lessons we learn can allow us to then scale this further across every local council district.
Also, the point has been made to us that whereas affordability might be less challenging across the whole council area, there's quite often hotspots in council areas too.
Maybe put that in a different way then. What are the 3 council areas that you hope to progress into in the future?
Very good.
I don't have a list of them in front of me, and I'm
there's at least 2 of the schemes which are very close to other council areas, and I'm not sure where they are across the line, so I would not like to mislead you.
Can I just remind you that this is a scrutiny committee, and we don't want to be hearing everything by announcement. We want to understand the dynamics of how this is being planned, to input into that. So that's the spirit in which I think you should address this.
Yeah.
Well, I think it's fair to say, and John, keep me right here, since the application came in from Mabel and May, things have changed. So you'll know that construction of houses is quite a dynamic process. Planning permissions come in, things move. Since the pipeline came in, some of those sites have dropped out and new sites have dropped in. So it is a dynamic picture, and we wouldn't want to be misleading the committee by saying they're definitely going to be in these 8, not in those 3. And it's not a matter of trying to obfuscate or hide anything from you, but it still is a work in progress.
Can we tell you as soon as we've finalised it?
Well, yeah, and in advance of an announcement, please, because I think it will be important that we understand that.
The Housing Executive have a report that's been published, if that helps you, where it lists the average rents, and it looks like the lowest ones there are Fermanagh and Omagh, Mid-Ulster and Derry Strabane.
I don't know, why do you look at me? I can't
No,
answer
that's
that
just
question.
no, but it's just
What Kelly's saying is there on the face of it, and in terms of housing executive, that would be the 3 areas where none of these homes would be going, and that would be a concern, I have to say. So give me.
I wouldn't come to that conclusion.
Okay. Well, fair enough.
I'd appreciate if you would come back and confirm just what, in fact, it is we're
I just
talking
want
about
to
there.
pick up Maryann. This is the first 300. We're very happy to be having them quite spread out because it's a test and learn. So actually, you could. Your initial question was, I could. Looking in at this, you say, well, it'll all be in Belfast, won't they? Because that's where the rents are highest, and somebody will build a couple of apartment blocks, and that'll be it. They'll all be in 4 buildings in Belfast, or they'll all be in the high rent areas in Lisburn, some bits of Ards and North Down, but I mean the south of Ards is not a high rent area, but they're not. They're spread out. We're going to get to see how they work in all sorts of different markets, and we're very happy with that because we want to see how they work in all different markets. But we have no ideological objection to having them anywhere that they're needed and that they will work.
Well, not only should there not be an ideological objective, it should be an ideological imperative that they would go into those areas. And I'm often struck by the example of during COVID, Conor Murphy brought out a scheme to put working from home. I'm using this as an example into council areas. There were to be 11 done. Out of those 11, and it was halted then as COVID, it came to an end. Out of the 11. 5 of the ones which got built, there were 6 done, 5 of which were done were east of the Ban, which in my mind is where they were least needed in many respects. And of the 7 that weren't built, 6 of those were west of the Ban where they're badly. So what I'm saying is when we're using public funds, we should be addressing inequalities and we should be addressing need. So rather than taking I get it, these are the first 300 and as we move on we'll do, but I'm saying you should be from the very outset doing those things.
And
if I could just finish maybe with the questions that I had on that as well. In fact, I was listening intently because that, if anything, was foremost in my own mind again too, with the allocation of the houses and so on. And I was a wee bit surprised that the example that was used was in Dublin, where they had this excess demand and they had to resort to a ballot effectively, right, where they drew them out of a hat. Well, one of the greatest organisations that we've had here in the north of Ireland as a result of our troubles has been the Housing Executive and the way they ensure there's fair allocation of houses. And in particular too, they can be seen as an instrument for social engineering in many respects. And I wonder to what extent then do you take that same responsibility on board, because at the end of the day, in the likes of Dublin, you won't have the same types of difficulties or problems in terms of integrated communities. That's what we have here in the north of Ireland, which is very much the country we live in at the present time. And I was wondering that in your case then, how is it that you include that in whatever model it is that you have in terms of ensuring that there's a fair allocation of houses that also meets that community objective in many respects.
Social housing, these are private rented houses, so the eligibility criteria are much simpler as we set out. So I suppose what John was saying is, what do you do whenever you get a number of households who basically all meet the target? As you know, the Housing Executive social housing is based on housing need, and it's a very complex in some cases assessment of an individual household's circumstances, and it results in a point system which takes into account multiple things and is very, very complicated. So that's not what we are doing. That is the social house, that will still be here, but you're right entirely, it has to be fair and transparent and to be seen like that. and to be auditable, you know, and overseen properly, and people to have trust in it. So the process will have those things which we need. It can't be done behind closed doors. People can't think that it's done by some sort of, you know, these houses are doled out to your staff's children, or anything, or councillors can intervene to get somebody a house or anything like that. There's going to be nothing like that. So we need to think of a way, and we haven't finalised it yet. We need to think of a way that, you know, we apply the criteria, but if we do get people who all meet the criteria and they're all in the same thing, that we work out how to pick between them if there's more than that, more people than there are houses.
Well, I'd appreciate
so that is a bit of a challenge. You're right, and it's very different to social housing. We can't replicate a social housing system.
I can totally understand that, but I'd appreciate that kind of information to see how it is that you actually operate in itself, so that whenever you have arrived at a conclusion about the other 3 council areas and you feed that back to us, maybe that kind of information, if it's contained within it, would be a help to Cormaga.
Thank you, Melissa. Brian.
Okay, thanks for the presentation. It's very, very interesting to hear more detail of this. So is it fair to summarise that it's a public subsidy for lower income households in areas of high private rental value? Is that correct? Yeah. And it's primarily then for people who can't get social housing, maybe because of the number of points, you know.
I'm not sure.
That's another route into. Well, they're going into private rental, but there's a public subsidy towards it.
Yeah. So we always thought that there would be some people who maybe were on the list and had lower points. Yeah. Lower income working households.
They can't get a social housing because you don't have enough.
Yeah. So people maybe a generation ago who might have got social housing but are now in the private rented sector. Right. But there's other groups that you might imagine. I mean, there's, as you know, there are people who don't put themselves on the list for whatever reason. There's not many social houses in their area. They don't see any point in putting themselves on the list. They might want to apply for them as well.
Yeah. And do you envisage that the tenants of these houses, what they're actually paying, would be maybe slightly higher than what someone paying full rent for a social house is? So it
would be intermediate between
yes, but they'll be paying less than what somebody renting off a private landlord, right? So, but probably paying, and it's all going to be new build. There's no existing properties. Will they all be choice developments, or might some of them be developments being brought forward by other housing associations?
Mixture.
So it's not just choice developments, but the intention is these will be mixed tenure developments, which is the norm now anyway, where you'll have some social housing, some private, hopefully owner-occupier housing, and some intermediate rent through Maple and May.
I think we're still confirming, and there's.
Or do you think there'll be developments that are all intermediate rent?
There might be some smaller ones which are all intermediate rent.
Right. Okay.
Yeah, but some of them will be part of larger developments which are mixed tenure.
Yeah. And I'm still wondering what this means in practice.
See how it would extend to other housing associations, because obviously Maple and May work very closely to the choice. But if I was another housing association and I was being asked to do mixed tenure, I would be calling Jon and saying, I have these houses, the council has told me I can't just have all social, I need to have, so could you take these as intermediate rent and run them for me, or something like that. You can see how it might develop.
It counts as the category of affordable housing.
It's affordable housing under planning policy.
And I'm still wondering how this works in practice. There's no point system or allocation process involved. So I thought you're likely to be oversubscribed for this. So are you saying you haven't decided how you will decide, or you've yet to draw up that system? But is it fair to say, and this model exists elsewhere and is oversubscribed?
Yes.
And how do they do it elsewhere? Is it true that they do it by ballot?
The one in Dublin, Boland's Mill, was the one which was allocated a few months ago and was heavily oversubscribed. So you can go on. They ultimately, when they went through, so they put out a lot of people for earning too much.
Yeah.
We'll also look to make sure no one's applied who really has no chance of paying the rent, and this would be unaffordable to them. So there's the bottom end of it too. But when they had their criteria, they were left with more eligible people than there were apartments, and they did a ballot.
Right.
Yeah.
Okay.
So that was how they did it.
Okay. Because you don't want to replicate the social housing model with points and so on.
Realistically, we can't set up another one, and then I mean, once we get more of them and there's a churn in them and things like that, you know, it might not be. I mean, the Boland's Mill one is, you know what Dublin's property market is like. If somebody's putting up a block of apartments and they've got cheaper rent and they're in the middle of Dublin and they're lovely, because I've seen them, they're lovely. Obviously, half the city was interested in that.
And it's meant to be a fixed duration. Well, is it seen as not a long? You talk about a 5-year rental. It can be renewed, but ideally you don't want it. Well, how would you term that? You prefer to see churn. You prefer to see people moving on if their income changes, that sort of thing.
So it's intended to be an intermediate. So it's bridging the gap between a secure, permanent social house and a 12-month on reputation private rental, where people aren't sure in 13 months' time, will I still be in this house? So it gives people the opportunity to say, right, I'll, subject to mutual agreement with their landlord, I'll be here for at least 10 years.
Right.
So everybody has the opportunity to renew a 5-year with a second 5-year. There may be exceptional circumstances. For example, if somebody has adaptations done to their intermediate rent house, they may ask for a third tenancy, and that might be acceptable because that suits their needs, etc., etc. There may be people who don't need it for 5 or 10 years. There may be people who say, if I had this discount in rent for 3 or 4 years, I could gather together a deposit to get into co-ownership. So there are a couple of cohorts of households that this could help at different stages in their housing life, if you like.
Okay.
A lot of people move through the private rental sector, so you base it as the private rental sector, how can we make that better? Then a lot of people move through it's quite often it's a stage of life thing.
Yes.
Yeah, so you're helping people at the stage of life when you need it.
Actually, the 5 years is longer than
it's
normal.
It's much better than people who've
got
got 1 year.
It's not seen as a limit, it's actually seen as giving a bit of stability.
Yeah.
Right. And I'm interested there, you're saying you actually adjust the rent for the size of the households. Is that in terms of the eligible lower income household, 30,000 for a single adult or 40,000 for 2 or more household adults? But will you adjust? You'll have to keep asking people about their income and who's in the house. Do you say it's only once a year you can adjust the rent though?
So that is one of the rules, that the rent can only be changed. So that's a statutory rule. That's not specifically intermediate rent. We wanted to put in provisions to make sure that this starts affordable and remains affordable. So we put the CPI plus 1% up to 5% cap. We also examined how this works elsewhere. Do people's income, is there a perverse disincentive to people going for a promotion or creating a relationship and expanding their household because it affects their income? So it's when you're in, you're in. If you meet the eligibility criteria at the start, we aren't going to come back every time and say, are you still under that category? But when it comes to renewing your tenancy, Mabel and May, I'll be asking people, are you still able to afford this? So there'll be an opportunity then to make sure that people are still finding this affordable, that they can sustain this tenancy, rather than this as a mechanism to move them on.
And last question, Chair. FTC is a loan, so will Maple and May ultimately pay the money back? I mean, there is still a public subsidy going into this.
Yes, it's a low-cost loan. The interest rate's very low.
Right.
The interest rate is set at a level for the department to cover its costs. So that's a subsidy.
Yeah, but money does come back from Maple and May and to hopefully perpetuate.
Well, it's cycled over again.
Yeah. Okay, thank you.
Thank you. What's your understanding of what an average intermediate rent would be in terms of length of time tenancy? Or is there such a figure? I know we don't have it here, but from other learns, I presume you've picked up on learning from other places.
So when people tend to get in, they tend to stay for as long as they possibly can, and most people organically move on. They either get an allocation or they move into affordable home ownership. So that kind of 10 years is sort of towards the top end. And as I say, there would be exceptions to that where there are specific circumstances for a household. But that's in and around what the average would be.
I mean, the average length of time in a private rented house is between 2 and 3 years, we think. So
that's not normally the tenant's decision. It's normally the landlord's decision.
There you go. Yeah.
Okay, and just a wee quick final one then. Are you confident enough that things are moving along in a way that ensures that the FTC money remains in place and that we're going to meet all targets, that there are no risks to that funding stream?
I mean, obviously we're proposing to make the loan next year, so we're on a 1 year budget for this year, but all the indications are is that we should be able to there should be FTC available next year, there's actually, in the last spend review, there was an announcement more FTC would be available.
Okay, well listen, thank you for that. It's an interesting development, and as I say, you know, in broad terms, absolutely welcome anything that sees more affordable homes getting built and people getting access to those homes. I would like, I think we will want to keep our finger on the pulse in terms of how these decisions, how this is rolling out. So I would welcome the commitments you've made to getting some further information back to us and future information, if you could feed that into us as quickly as possible. I think it's one we're very interested in.
I thank you for brilliant questions. They're very engaged and really excellent questions. Thank you very much.
Okay, thank you David, Maryann and John. Thank you all for that.
We want out to visit them.
Next to it.
More jealous.
Any follow-up actions, members, in terms of that? Go ahead,
It would be interesting just to know if the Housing Executive has been measuring the numbers of people here to get a feeling. You know, we know how many people are on the waiting list for social homes, but this type of home, if they have an idea of that banding of person, how many there are in Northern Ireland, it would be useful to find out.
Or to use
members, sorry, Melissa, come back to you. Content we seek that?
Yeah.
Melissa?
Just use another terminology, ceteris paribus, all else being equal. I wonder how it is that they do end up then deciding who gets what. In fact, it's purely just on the ability to pay the rent. You know, I don't know if that's the case or not, so I think it'll be interesting. And it's to be welcomed, you know, the very fact that if you can increase, say, the housing stock, that in itself is a welcome development in every respect. By the same token, you'd like to ensure too, but that it's equitable and fair for everyone.
Yeah, and I think there is an element there where I get the fact it seems almost crudely unsatisfactory that you would have a ballot for who would get it, but I understand you have to have some way after applying criteria and demand still exists. You have to have some way. My worry would be to ensure that the people of Tyrone have a chance to be in a ballot. So that's one element of it that I would be keen to keep an eye on, and I know they have committed to bringing more information back, so I think we're okay in that sense for now, but I will want to keep an eye on that.
It is part of the project to help those who are the working poor, you know, who are not necessarily in receipt of universal credit because their income is just beyond that level, but they're never going to get, if they're earning 30 grand, they're never going to get a mortgage on that amount of money for a single person, and co-ownership might be a bit tight for them. So it is a product that will give people an opportunity. Yeah, so it has to be welcomed. I just worry, I hope that this doesn't take over from the investment in social homes.
Yeah, I think there's lots of moving dynamics to it, and I think we will need to keep a close eye on it, I think. But it's worthwhile. It's good that we have something you know. It's a positive thing to be watching. Is what I really want to say. Okay, members. So thank you for that. Clerk, are you content that we have everything that we need in that session?
Yeah.
All right, members. Moving forward to the last two items on the open, before we go into our briefing on the arts report. Forward work programmes, agenda item 10, which is contained at page 236. Do members have any comments, or are they content to note the forward work programme?
No, grand.
Thank you. Agenda item 11 is any other business. Do members have any other business they wish to raise today? No. Thank you. Agenda item 12 is date, time and location of the next meeting. Our next meeting will be at 10 a.m. on Thursday, 26th of June 2025 in the Senate Chamber, when we'll be hearing evidence from Action Deaf Youth on the bill, along with a briefing from the bill office. Members content. The meeting is now adjourned, and we will move into closed session with members' agreement.
Agreed.
Thank you.